Now I request Sri K. Chidambaram Garu, Senior Advocate and President of AP Advocates Association, to come on to the dais and adorn the chair. Sri Chidambaram Garu, the President of the Association, is coming. And I request Sri AVS and Murthy and Sri Kiran Babu to present bouquet to the President of the Bar Association. Now I request Sri Dammalapati Srinivas Garu, the learned advocate general, State of Andhra Pradesh, to come on to the dais and adorn the chair. Sri Dammalapati Srinivas Garu, the Advocate General of AP. I request Swarnalata and Uma Devi, Executive Committee members, to present the bouquet to the Advocate General Sri Dammalapati Srinivas Garu. With immense respect and admiralty, I invite our beloved Chief Minister of Andhra Pradesh, Sri Nara Chandrababu Naidu Garu, to come on to the dais and to adorn the chair. Sri Nara Chandrababu Naidu Garu, the Chief Minister of Andhra Pradesh, is now coming on to the dais. I request Jampani Sridevi and Tota Yogeshwar Rao to accompany the Chief Minister of Andhra Pradesh. I request Sri Subodh, General Secretary, and K. Dheeras, Executive Committee member, to present a bouquet to the Honorable Chief Minister of Andhra Pradesh. Now I request the Honorable Sri Justice Dheeraj Singh Thakurji, the Chief Justice of Andhra Pradesh, to come on to the dais and to adorn the chair. And I request Prasannala, EC member, to accompany the. I request Pitani Chandrasekhar, Joint Secretary, and Kone Satyananda Rao, Executive Committee members, to present a bouquet to the Honorable Chief Justice of Andhra Pradesh, Justice Dheeraj Singh Thakurji. Now the affectionate guest of the today's function, I request the Chief Justice of India, Sri Justice Bhushan Ramakrishna Gawai ji, Chief Justice of India, to come on to the dais and adorn the chair. I request all the people to give the big round of applause to the Honorable Chief Justice of India. And I request Mr. Murthy and Kiran Babu to accompany the Honorable Chief Justice of India. Welcome you, sir. And I request Mr. K.V. Raghuveer, the Vice President, and Y. Durga Rao, the Treasurer of the AP Advocates Association, to present the bouquet to the Honorable Chief Justice of India. And now I request Mr. Chidambaram, the President of the AP Advocates Association, to take over the further function procedure.
Now prayer by N. Shobha, Judicial Officer.
Good morning, eh? Vande Mataram, Vande Mataram, Sujalam, Sufalam, Malayaj Sitalam, Sasyashyamalam, Mataram, Vande Mataram. Rajosna pulakitayamini pullakusumita drumadala shobini suhasini sumadura bhashini sukadam varadam mataram vande mataram vande mataram.
Now Now I request Honorable the Chief Justice of India and other dignitaries on the dais for lighting of the lamp.
शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः दीपो हरतु मे पापम् सन्ध्यादीपनमोऽस्तुते ओ दीपब्रह्मरूपस्थं ज्योतिषां प्रभुरव्ययः ओ दीपब्रह्मरूपस्थं ज्योतिषां प्रभुरव्ययः आरोग्यं देहि पुत्रांश मतिं स्वच्छ मे सदा रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत् रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत् यस्य तिष्ठे गृहे दीपः तस्य नास्ति दरिद्रता
Good morning, everybody. I welcome Honorable the Chief Justice of India, Sri Justice Bhushan Ramakrishna Gawai ji, Honorable the Chief Justice of Andhra Pradesh, Justice Dheeraj Singh Thakur ji, Honorable the Chief Minister of Andhra Pradesh, Sri Nara Chandrababu Naidu garu, Honorable Judges of High Court of AP, Learned Additional Solicitor General, Learned Advocate General, Learned Solicitor General, Learned Deputy Solicitor General, Learned Public Prosecutor, Registrars of High Court of AP, Judicial Officers, Senior Advocates, Law Officers, Officials of the Advocate Brothers and Sisters, and other invitees. It is a profound honor and privilege to extend a heartfelt welcome to the Honorable the Chief Justice of India, Justice B.R. Gawai, on behalf of AP High Court Advocates Association and everyone gathered here today in Amaravati. Your presence graces this occasion with immense dignity and inspires us all to reaffirm our commitment to justice, equality, and the rule of law. Justice B.R. Gawai has charted an extraordinary legal journey, beginning as an advocate in 1985 and rising to become the 52nd Chief Justice of India in 2025. His distinguished tenure as a governmental pleader, public prosecutor, and judge of the Bombay High Court for over 14 years stands as testament to his exceptional legal acumen and unwavering dedication to public service, profoundly shaping his understanding of the law as a powerful instrument for the empowerment and welfare of citizens. Among his landmark Supreme Court judgments are the historic decision upholding the abrogation of Article 370, transforming Jammu and Kashmir's constitutional status, validating the demonetization scheme of 2016, and the striking down of the electrical bond scheme for violating water rights to information. Justice B.R. Gawai's conquering opinion in a landmark ruling upholding the power of states to create subclassification within scheduled castes to ensure fair reservation benefits, made valuable constitutional insights, emphasizing the need of social justice to adapt to the realities of marginalized communities. Justice Gawai's illustrious career stands as a beacon of compassion and judicial excellence. His journey from the bar to the bench and now to the highest judicial office in the land reflects not Honorable Justice Dheeraj Singh Thakurji, Chief Justice of Andhra Pradesh. Justice Thakurji began his legal career after enrolling as an advocate with the Bar Council of Delhi in 1989. Later shifted his practice to Jammu and Kashmir High Court in 1990. Over the years, he built reputation for his deep understanding of constitutional, civil and taxation law. He was elevated as Judge of Jammu and Kashmir High Court in 2013 and subsequently served with distinction at the Bombay High Court. His Lordship judgments are known for their clarity, fairness and adherence to constitutional principles. In July 2023, His Lordship assumed office as the Chief Justice of High Court of Andhra Pradesh, where His Lordship continued to uphold the highest traditional of judicial excellence. His Lordship is instrumental for various welfare activities being done by the AP High Court Advocates Association in the interest of its members. Throughout his illustrious career, Justice Thakurji has been admired for his intellectual rigor, humility and unwavering commitment. Blend of legal insight and compassion, qualities that define the finest members of the judiciary. On behalf of the AP High Court Advocates Association, it is my privilege to warmly welcome His Lordship Justice Dheeraj Singh Thakurji on this occasion. We are deeply honored by Your Lordship's gracious presence and will look forward to hearing Your Lordship's words of wisdom and inspiration. Thank you, sir. Today, we are privileged to have among us a visionary statesman and a leader who has been instrumental in steering Andhra Pradesh towards progress and prosperity. The Honorable Chief Minister of Andhra Pradesh, Sri Nara Chandrababu Naidu garu. I welcome you, sir, on behalf of the AP High Court Advocates Association. Chief Minister's name is synonymous with dynamic governance, forward-looking leadership, and an unwavering commitment. Has demonstrated that leadership is not merely about authority, but about service, compassion, and a vision. His administration has prioritized inclusive growth, ensuring the development reaches every corner of the state and benefits every section of the society. Under his stewardship, Andhra Pradesh has witnessed remarkable transformation across sectors, be it infrastructure development, digital governance, education reform, agriculture modernization, or social welfare. His focus on empowerment, particularly of farmers, women, and youth, reflects a leadership grounded in empathy and foresight. He has consistently emphasized that progress must be both sustainable and equitable, echoing the true spirit of democratic governance. Beyond policies and norms, what truly stands out is his ability to connect with the people. His approachable and compassionate manner has earned him immense respect and trust from citizens across all walks of life. His governance reflects a deep understanding of local needs, coupled with a global outwork, a combination that continues to place Andhra Pradesh on a progressive and spiritual path. On behalf of everyone gathered here today, I extend our warmest and most respectful welcome to the Honorable the Chief Minister of Andhra Pradesh. Sir, your presence here adds great significance to this occasion, and we are deeply privileged to have you among us. We look forward to hearing your words of wisdom, which will no doubt inspire and guide us towards continued excellence and collective progress. Sir, I would like to take this opportunity to respectfully respect your kind consideration for allotting a suitable parcel of land in the Amaravati area to the AP High Court Advocates Association at a reasonable cost. This will enable the members of the AP High Court Advocates Association to construct at least apartments on their own resources, fostering cooperative housing development and supporting their housing needs. Thank you, sir. Thank you very much. Now I request the Learned Advocate General to speak on the occasion. Thank you, one and all.
Honorable Sri Justice Bhushan Ramakrishna Gawai, Chief Justice of India, Honorable Sri Justice Dheeraj Singh Thakurji, Chief Justice of Andhra Pradesh, Sri Nara Chandrababu Naidu Garu, Chief Minister of Andhra Pradesh, Honorable Judges, Sri K. Chidambaram, Chief President, AP High Court Advocates Association, Honorable Judges of District Judiciary, Senior Advocates, Friends of the Bar and distinguished guests. It's an honor and privilege that Sri B.R. Gawai, Honorable Chief Justice of India, Sri Dheeraj Singh Tagore, Chief Justice of AP, and Sri Nara Chandrababu Naidu, Chief Minister of AP, have graced us with their presence today. It is with immense pride that I stand before you today on this momentous occasion celebrating the Indian Constitution. On the 26th November 1949, the Constituent Assembly of India gave its final approval to the Constitution of India, and we remember and celebrate that milestone as the Constitution Day. The Constitution is not only a legal charter, but a reflection of the aspiration of a free and democratic India. It is our compass and our North Star guiding us through the complexities of a diverse and dynamic society. As Dr. B.R. Ambedkar rightly observed, the Constitution is not a mere lawyer's document, it's a vehicle of life, and its spirit is always the spirit of age. Nothing encapsulates the statement better than the several judgments of the Honorable Supreme Court, recognizing the dynamic nature of the Constitution and recognizing it for truly what it is, a living organ and an embodiment of our shared commitment to building an India that is just, inclusive, and equitable. We observe this dynamism every day, most recently when the Honorable Justice B.R. Gawai, present with us today, in his important and landmark subclassification judgment, found that the Constitution has provided us with the means to interpret it by considering the stark ground realities so that the country can achieve real equality as envisaged by the Founding Fathers. He found that Constitution itself provides us the means to truly and equally provide for oppressed classes, and an equivalent duty is also cast upon the executive and legislature to ensure that policies are framed to achieve the said object. True economic and social growth is only possible when all the citizens are provided for duly upholding the constitutional values. Honorable Chief Justice Gawai's judgment in the demonetization case and in upholding the validity of an unstamped arbitration agreement has paved way for significant economic reforms and ease of doing business. He stood against corruption, demanded accountability, promoted rights and dignity through several of his judgments, including the Prabir Purkayastha's case. The Constitution is termed as a living document due to the liberal interpretation it is capable of. Equally, it does not exist in a vacuum, but is judged and amended to suit the evolving needs. From Keshavananda Bharati to the subclassification judgment, we can see that the Constitution does not exist detached from our society. Rather, it exists in the present. It exists for those who are and those who will be, so that the idealist vision may become a reality. As B.R. Ambedkar said, however a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good. The judiciary is the final arbiter and interpreter of the Constitution, and we as advocates have immense duty to uphold the constitutional values and we have to remind ourselves that fight for such values is not fought in grand gestures but in the quiet, relentless pursuit of fairness and justice. It is fought in every petition filed to protect citizens' right and in every argument advanced to uphold justice. We therefore have to ensure that we implement the Constitution and its principles in its true letter and spirit. As rightly recognized by the Honorable Supreme Court, it is always profitable to remember the famous line of Lawrence H. Tribe that a constitution is written in blood rather than ink, and we need to ensure that the essence of the constitution is preserved in its present form. Thank you.
Now it is a turn of our visionary leader and dynamic Chief Minister of Andhra Pradesh, Nara Chandrababu Naidu Garu. I request you, sir, to address the gathering on this occasion.
Honorable Chief Justice of India, Sri Justice Bhushan Ramakrishna Gawai Garu, Honorable Chief Justice of High Court, Government High Court Andhra Pradesh, Sri Justice Dheeraj Singh Thakur Garu, Honorable High Court of Andhra Pradesh, Advocate General Dammalapati Srinivas Garu, President of Andhra Pradesh High Court Advocates Association and Senior Advocate Chidambaram Garu, General Secretary of Andhra Pradesh High Court Advocates Subodh Garu, other distinguished advocates and also other invitees, friends. It is a great privilege to be at an event being hosted by the Andhra Pradesh High Court Advocates Association and graced by none other than the Chief Justice of India. We are in Amaravati. I am very happy to notice he came from Amaravati. Both are synonymous for historical. All people in India believe Amaravati is the angel's capital. So, always His Excellency, Honorable CJ, during his career have seen very simple, humble, down to earth, while discharging his duties is always upright. Even we have delayed our meeting for 2 minutes. Reason is he wanted to maintain equality. People will say equality. He is practicing equality. That is how we can understand his philosophy. I really appreciate him. I have seen judges, honorable judges, and also CJs in respect to time. But I have seen new human being in Gawaiji. That is where I am admiring him. That is how he is conducting. If you see his track record, from the beginning, with a impeachable record, he left a great legacy as 52nd CJ of India. People will remember all his judgments. I am poor in judgments because I am only a politician. I know what to do people. Then by taking advice from judiciary, how to do according to law. We all have witnessed his distinguished professional journey as a lawyer, as a judge of the High Court and Supreme Court, and as the Chief Justice of Highest Court. I look forward to an enlightened keynote address. Always I am saying I am a student. I wanted to hear people, learn from them what all possible for execution I want to execute. All of us has to remember Ambedkar ji. Ambedkar has given excellent constitution for all of us. All times tested constitution. I am here as a Chief Minister. Our Gawaiji is here as CJ. Our CJ from High Court, we are all because of him. That is the strength of our Constitution. Even beauty of our Constitution, Narendra Modi ji has claimed very proudly, I was a chai wala. Chai wala has become Prime Minister of India, and also not only Prime Minister of India, great Prime Minister of India ever we have seen. You will create a record. That is the beauty of this Constitution, to uplift people. We have seen so far, originally 17 crore voters, now around 97 crore voters in 24. So many elections, so many democracies we are seeing. One of the best democracy in the world, India, no doubt about it. And also, countries are progressing in communist countries because there is no election. Countries are progressing in rulers, kingdoms, even Gulf countries. But visit so many countries for marketing our economy or investments. Everybody used to see India very poor light. As a matter of fact, they used to say Hindu growth rate, equaling by saying 2%. At that time, China used to grow double-digit growth. One is, after economic reforms, thinking process has been changed. People are viewing in different way. Mid-90s, IT revolution. India has taken first mover advantage, that has been changed totally. Now we are having demographic dividend as a windfall. Even recently, Taiwan, I had a delegation with them. Being a high-tech country, all innovations are going on. 23 million population. They need people from India. Only in future, India can supply human resources for the global community. They may be very strong in technology and also hardware and software, but nobody can replace human beings. That is the biggest challenge world is facing, but India is going to have that advantage. I wanted to place before all of you, who have seen Narendra Modi's regime today. 2011 or 2014, 11th largest economy. Today we are 4th largest economy. By 1 year we are going to become 3rd largest economy. By 2038 we are going to become 2nd largest economy. 2047 100 years of independence. Now we are celebrating 75 years of constitutional adoption. I am confident India will be number one in the world. That is the power of India and Indians. And also here, if you all of us can see, Indians as on today all over the world, highest per capita income earners. By 2047, Indians will be globally most influential community. It is going to happen. In this context, 4 pillars of democracy. I want to share this type of intellectual forum. Always if you see legislature, executive, judiciary, media, always legislatures, once in 5 years you have to face. People give mandate, then only will come to assembly. Executive is a permanent body, tenure. Judiciary, compared to other fields, more stability, and also whenever there is something going wrong, you are correcting and putting democracy in right spirit. That is how things are happening. Now media has come. I have seen media. Once only All India Radio. That is only the breaking agency. Afterwards I have seen newspapers. Only one paper. At one time, Hindu paper used to come. That is only the paper, trusted paper. After that, electronic media has come. Now social media has come. Social media, every person is an editor. Every person is a writer. They can write anything. They can express their views. They can character assassination also. No exemption for anybody, for me, for judiciary, for everybody. That is how we are facing today. This is the right forum. I want to interact all of you. We wanted to maintain vibrant democracy. And at the same time, nation first. We are all here. Nation is great. We will be proud of it. If nation is not great, all of us will be looked down. This is why asking all of you to contribute further. If you see one thing, Ambedkar has given, one person, one vote. Even some constituents didn't give equality for everybody. Women, some great countries didn't give equal rights. Only the country, poor, rich, no gender bias, or even billionaire, even poorest of the poor are having one vote. That is the biggest advantage for Indian democracy. And here, he gave political equality or equity. Now it is our responsibility to bring social equality and economic equality. That type of society, that type of nation we have to build. For that, always I consider public-power deadly combination. Around 1995, I created one public policy promoting information technology. Within 25 years, Hyderabad, because of knowledge economy, highest per capita income, and also today all Telugu community and Indians all over the world, highest per capita income earners. It is only one public policy. Now we have to see further. Rich and poor are dividing. Sharp. Consciously, all of us has to create how to bridge the gap between rich and poor. Everybody will have better living standards. I have seen so many things. Now I am dedicating myself. I am working with all your blessings. Wealthy, healthy, happy society that will be long sustainable. Compared to any other country in the world, Indian family system and values are the best in the world. That is giving so much of strength for all of us. We have to prove that is where our Honorable Prime Minister is saying always, Vasudhaiva Kutumbam. Total globe is one family. We are seeing global good and also everybody's welfare, everybody's happiness, and at the same time, we should not interfere any sovereign powers. Anybody will interfere in our sovereign powers. That is what he thought Sindoor. It will repeat, anybody will violate. I am very happy in this intellectual forum to share some of my thoughts. I need your feedback, continuous effort. We are all great nation. We are all partners. People like Honorable Justice Gawai has to guide this nation continuously for upliftment of this great nation. With this, I am thanking all of you. Thank you, Ananda.
Now I request Honorable Justice Dheeraj Singh Thakurji, Chief Justice of High Court of Andhra Pradesh, to address on this occasion.
Just come with face. Keep it slightly. The Honorable Chief Justice of India, Shri Bhushan Ramakrishnan Gavai, Honorable Chief of Andhra Pradesh, Shri Nara Chandrababu Naidu, Learned Advocate General Shri Damalpati Srinivas, President Andhra Pradesh Court Advocates Association Shri K. Chidambaram, esteemed brother and sister judges, judges from the district judiciary, distinguished members of the bar, ladies and gentlemen. Today we gather here to celebrate the 75th year of India's adoption of the Constitution. There is a deep sense of pride and achievement for the many milestones that we have attained over the decades. Consider the context in which we began the journey towards independence under the colonial rule. It was not easy. For the British, India was a huge landmass with an equally huge and complex population. What was missing was a sense of accountability to the Indian people as the source of authority vested in and not in the Indian people. On the other hand, the mass of the Indian people who were the non-elite, the concept of constitution, democracy or rights was alien. In many ways, their suffering, exploitation and oppression made them realize the value of freedom and human existence. Indeed, it was a paradox that over time, even as the British themselves became democrats, they continued to deny to the Indian people their basic rights and freedoms. Therefore, the making of the Constitution by the Indian people for the Indians is not just a facet to be stated textually, but is an experience, a reflection of a deep emotion, philosophy, and a sense of belonging. On December 13, 1946, the objective resolution presented in the Constituent Assembly of India spelt out the vision of a new India. It declared that territorial unity and integrity of India should be preserved. As a sovereign independent republic, India would derive power from the people with social, economic and political justice, equality and freedom Indians. It also declared protection and safeguards for minorities, backward, disadvantaged and the poor. This spirit of the Constitution was later embodied in the preamble of the Indian Constitution, which was adopted on November 26, 1949. Throughout the deliberations in the Constituent Assembly, three concerns dominated the debates. national unity and integrity, democratic institutions and social revolution in an interwoven way, as none of it was possible to achieve in the absence of the other. Parliamentary democracy with adult franchise was the obvious choice, given our familiarity with the British working India. Clearly, from integration of princely states to centralized federation, which we call the Union of India, to fundamental rights, directive principles, and constitutional schedules, there is no better example of indigenization of democracy than that of India. While fundamental rights were borrowed from the American Constitution, India went beyond the formal equality provision to add substantive equality element by providing for reservations for scheduled castes and scheduled tribes. Again, it is significant to mention that the Indian Constitution had the rare distinction of being one of the most comprehensive constitutions of the world, with 395 articles, 22 parts and 8 schedules, when it was framed, began to seem inadequate in the face of renewing changes in the society over time, calling for additions and alterations in the existing scheme of things. Arguably, citizens' perceptions about events, situations, needs and aspirations change over time, which has evidently resulted in 106 amendments to the Constitution of India till date. We can recall how institutional dynamics post-independence put the Constitution of India to test, as in the First Amendment to the Constitution in 1951. Subsequent deeds brought into focus landmark cases, each of which, while raising critical questions of law on fundamental rights, basic structure, and parliamentary propriety, also shaped the norms and procedures of democratic institutions in India. Cases like Shankari Prasad, Sajjan Singh, Golaknath, Keshwananda Bharti, S.R. Bomai form crucial chapters in the constitutional history of India. Apart from this, a host of other enactments till date, like the Women's Reservation Act, the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act, Criminal Law Amendment Act of 2013, the Lokayukta Act, the Muslim Women Protection of Rights on Marriage Act 2019, illustrate the adaptability of Indian legal system to change. India has also moved forward in the domain of rights. A wider interpretation of Article 21 by the judiciary has brought some socio-economic rights from the directive principles within the scope of fundamental rights. Finding the right balance between the aspirations of a society and the sanctity of the Constitution has been a key element in India's continuity as an unfailing democracy. A combination of political and democratic institutions, including independent judiciary, free press, free media, a federal structure, and competitive multi-party system, among others, has all the way helped India to constantly invent and negotiate the contours of the Constitution to provide equality of opportunity, participation in, and include all sections of the society, keeping in view the specific regional, cultural, and economic realities of the time. Let us not forget that the mere existence of the Constitution does not guarantee a liberal state and can vary in form, content, and implementation. India has the unique distinction of adopting a Constitution which has not only given us a sense of dignity, identity, and self-worth, but also an exceptional design for governance that has been a source of our strength, stability, and endurance as a democratic nation. Therefore, the sense of purpose, commitment, and faith invested by the founding fathers of the Indian Constitution must serve as a constant reminder for every Indian not only to respect the Constitution but also protect it in every way. Thank you.
Now, we are all eagerly waiting to hear His Lordship's, the Honorable the Chief Justice of India, Bhushan Ramakrishna Gawai ji, on the topic of India and the living Indian Constitution at 75 years. Now I request the Honorable the Chief Justice of India to address the occasion.
Honorable Sri Nara Chandrababu Naidu Garu, the Honorable Chief Minister of State of Andhra Pradesh, Honorable Justice Dheeraj Singh Thakur, the Chief Justice of the Andhra Pradesh High Court, and all the Honorable Judges of the Court present here, Shri Amalpati Srinivas, Shri K. Chidambaram, the President of the Andhra Pradesh High Court Bar Association, all the other office bearers of the association, the senior government officials, the collector, the SP, the learned district judge of the district, and all the members from the district judiciary, the senior advocates, members of the bar, and friends. It's a matter of great pleasure for me to be here to speak with you on the successful journey of the Indian Constitution for last 75 years. It's a matter of great coincidence that after I took oath as the 52nd Chief Justice of India, the first function that I attended was at my native place, Amravati, and it was graced by my esteemed senior colleague and one of the greatest sons of the Andhra Pradesh, Chief Justice Ramna, who, without being invited, was kind enough to come all the way to Amravati to bless me. And now, before I end my journey as the Chief Justice of India, in a couple of days, the last function that I am attending is again at Amravati. So, the journey which begins at Amravati will be ending at Amravati. Both the Amravatis have a great historical significance. Our Amravati in Maharashtra is known as Indrapuri, the land of Indra, and similarly I think the Indrapuri here is also, Amravati here is also known as the land of Indra. I am really grateful to the Honorable Chief Minister, the Honorable Chief Justice of the High Court, and the members of the association, the President of the association, for inviting me and giving me an opportunity to speak with you on the 75-year journey of the Indian Constitution. The subject that I have been given to speak is India and the living Constitution at 75 years. As all of us know that, as the Honorable Chief Justice referred to, after the Constituent Assembly was constituted, the objectives resolution was placed before the Constituent Assembly on 9th of December 1946. It was presented by the then Prime Minister of the interim government, Honorable Shri Jawaharlal Nehru. Dr. Ambedkar, who was merely a member of the Constituent Assembly, was called upon to address by the Constituent Assembly, Shri Rajendra Babu, within 4 days, that is on 13th of December 1946. Dr. Ambedkar said that he was not ready to speak because, going by seniority, his turn would have come much later. But since he was called upon, he said he will share his views. And Dr. Ambedkar said that no doubt that the objectives resolution as presented by the Jawaharlal Nehru is pragmatic. He said it is lacking of two basic things. Dr. Ambedkar said that the objective resolutions provides for the rights, but it doesn't provide for remedy. And he said that rights without remedy are meaningless. And therefore we find that the very foundation of Article 32 in the Constitution of India, which enables every citizen to knock the doors of the Supreme Court of breach of fundamental rights, finds its place in the first address made by Dr. Ambedkar before the Constituent Assembly. Likewise, he said that coming from Pandit Jawaharlal Nehru, and who represents the Congress ideology, he said that there is nothing in the which provided for the social and economic equality. And therefore we find that the directive principles of the Indian Constitution, Part 4 of the Indian Constitution, which provides for directive principles, which is an instrument to achieve social and economic justice, also finds place in the Constitutional Assembly, in the Constitution. As all of us know that our Constitution stands on the 4 pillars of justice, liberty, equality and fraternity. The Constitutional Assembly put in Herculean labors for drafting the Constitution. 2 of the speeches of Dr. Ambedkar, the first one on 4th of November 1948, wherein he presented a draft constitution to the Constitutional Assembly, and the last one on the 25th of November 1949, wherein he replied the debates on the draft constitution, are, I think, most important speeches which every student of law should read. And as the Honorable Chief Minister said that he is a student, I am also a student of law, because I always consider that whenever a judge or a lawyer considers that he has now learnt everything, that is the end of a career as a lawyer or as a judge. And therefore, as a student of law, we must reflect upon the Constituent Assembly debates which went on for almost a period of 2 years and more, to understand what is the constitutional philosophy behind our Constitution. As the Honorable Chief Minister said that Dr. Ambedkar always considered, or rather for every citizen, the nation must be first. And Dr. Ambedkar in his first speech on 13th of December said that whenever the destinies of the nation are involved, the individuals, the destinies of the ideologies, the destinies of the leaders, the destinies of the political parties are totally irrelevant, and what is most important is the destiny of the nation. And therefore, in the heart of Dr. Ambedkar, it was India which was the most important. Coming to the main subject, that India and the living Indian Constitution at 75 years. Dr. Ambedkar always considered that a constitution cannot be a static document. It has to be evolving, it has to be organic and a living document. And therefore, the Article 368 provides for the Constitution, for the amendment of the Constitution. There was criticism on Dr. Ambedkar that on one hand he was criticized that the powers to amend the Constitution are too liberal, and on the other hand it was criticized that some of the amendments which require ratification by two-thirds of the states, by half of the states and two-thirds majority of the parliament were too strong, and it was difficult to achieve an amendment in this manner. He said that wherever amendments were necessary for answering the socio-economic challenges, the Constitution could be amended in a simpler way. But however, wherever a foundation of the Constitution like the independence of judiciary, the federal structure or the other important aspects are concerned, the power to amend the Constitution could not be simple, and therefore it was necessary that some more stringent conditions were required for amending the Constitution. As we see that we gave our Constitution to ourselves on the 26th of November 1949, and which came into effect from 26th of January 1950. The apprehensions as expressed by Dr. Ambedkar came to be true within a short period. In 1950, immediately after the constitution came, the state of Tamil Nadu, then the state of Madras, had issued a government order providing for reservation for the scheduled caste and scheduled caste. The same came to be challenged before the Madras High Court on the ground that it was contrary violation of Article 14. The said challenge was upheld by the Madras High Court. It was carried before the Supreme Court in a constitution bench judgment. And in the celebrated judgment of Champakaran versus the state of Madras, the Supreme Court upheld the judgment of the Madras High Court and held the provision of reservation to be unconstitutional. And therefore we find that in the very first amendment in 1951, the amendment which was moved by none else than Pandit Jawaharlal Nehru, Article 15 was amended so as to provide reservation for the backward classes. Similarly, between 1946 to 1950, various states, in order to provide for agrarian reforms, the Ceilings Act, like the Agricultural Tenancy Acts, had enacted various laws. Those laws were challenged. Some of the high courts upheld the validity of the laws. Some of the high courts negated the validity of the said enactments. And therefore, in order to bring about clarity, the same amendment also inserted Article 31A and 31B so as to provide for the agrarian reforms. Issue with regard to amendment of the Constitution came to be considered by the Supreme Court as early as in Shankari Prasad, to which the learned Chief Justice has referred to. And by a unanimous verdict, the 5 judges held that the Parliament's power to amend the Constitution cannot be restrained. It was held that if the Parliament, in order to answer the socio-economic challenges faced by the subsequent generations, is restricted for amending the Constitution, then the Constitution would be static or would not be a living document, and it will be a static document. That was subsequently considered in Sajjan Singh, by virtue of 3-2, the power of the Constitution, power of the Parliament to amend the Constitution came to be upheld. But the seats of dissent were sowed in the very same judgment. Justice Hidayatullah said that to hold that the Parliament's power to amend the Constitution are unbridled, and they can even amend the Constitution to take away the fundamental rights, I would require stronger reasons than the ones given in Shankari Prasad. Justice Mudolkar, he said that if the power to amend the Constitution is to be construed as taking away the basic features of the Constitution, then the word amend will have no importance and it will amount to changing the Constitution. And therefore we find that the concept of basic structure as evolved in Keshavanand Bharati has its roots in the case of Sajjan Singh. Secondly, the 9 judges in Golaknath held that the powers of the Parliament to amend the Constitution were restricted and it could not amend the Constitution in a manner it takes away the fundamental rights of the citizens. That gave rise to the 24th, 25th and 26th Amendment, by which various articles were either inserted or amended so as to carry forward the goal of the Indian Constitution of achieving social and economic justice. The same came to be challenged in the Keshavanand Bharati, wherein the Supreme Court, for the first and so far for the last time, sat in a combination of 13 judges. Insofar as the power to amend the Constitution is concerned, the court was virtually split by 6-6. 6 judges took a view that the powers of the Parliament to amend the Constitution are unbridled and the Parliament by majority can amend the Constitution in any manner. However, the 6 judges took a view that the Parliament's power to amend the Constitution are restricted and in the Constitution to take away the fundamental rights guaranteed to the citizen. It is only the view of Justice H.R. Khanna, partly accepted by 6 on one hand and partly accepted by 6 on the other hand, which is now the view in Keshavanand Bharati. Justice Khanna held that though the Parliament can amend the power even to the fundamental rights, it cannot amend the Constitution in a manner in which it takes away the basic structures of the Constitution. And therefore, the concept of basic future as found in Sajjan Singh, which was amplified as basic structure in Keshavanand Bharati, is what is the law which holds principles like the federal structure of the Constitution, the separation of 3 wings, the executive, the judiciary, and the executive, judiciary, and the legislature, the independence of judiciary, the supremacy of the Constitution were held to be the basic structures which were subsequent in various judgments, including the one in S.R. Bombay. As has been observed by the Honorable Chief Minister, it is all the 3 wings of the Constitution, that is, the legislature, the executive, the judiciary, which are enjoined upon to carry forward the mandate of the Constitution to bring in social and economic justice. One of the greatest weapons for promoting the social and economic justice as envisioned by Dr. Ambedkar was Part 4, that is the directive principles. And though we see that from 1950 to 1973, the tilt of the courts was always that wherever a conflict arose between the directive principles and the fundamental rights, the supremacy of the fundamental rights was always recognized. It was felt that wherever there is a conflict between the directive principles and the fundamental rights, the directive principles will have to give its way to the fundamental rights. It is for the first time in Keshavanand Bharati that this conflict was resolved. Though the court was virtually split on the question of Parliament's power to amend the Constitution, it was unanimous to hold that the directive principles and fundamental rights together and together alone are the soul of the Constitution. And therefore, Keshavanand Bharati held that the fundamental rights as well as the directive principles are together are necessary for progress of the nation. It was held that fundamental rights are those rights which are necessary for a human being, for a citizen to live a dignified life as a human being. Whereas the directive principles were the principles which govern the state, the legislature, and they guide them in order to enact the laws and take steps to further the promise of economic and social justice. Some of the honorable judges also held that the courts are also states within the meaning of Article 12, and therefore it is the duty of the courts also to interpret the laws and decide the cases in accordance with the directive principles. And therefore we find that in the 75 years of the Constitution, we have found the executive, the legislature, and the judiciary to be on the same page, and particularly after 1973. Many of the laws have been in furtherance of the promise of the social and economic justice, like the Tilling Acts, wherein a person cannot hold an agricultural land beyond a particular holding. The tenancy laws, wherein those persons who were tenants of the agricultural lands became owners thereof. And these all laws were held to be constitutional by the court, taking recourse to fundamental rights, particularly Article 39, 2B and C, which ensures the equitable distribution of the resources of the country. Though the fundamental rights of the citizens were affected by such enactments, the Parliament, the legislatures enacted them and the courts upheld them. Insofar as scheduled caste and scheduled tribe is concerned, to which again the Honorable Chief Justice referred with regard to reservation, the earlier view, as could be found in the cases of Devdas and Balaji, was that sub-article 4 of Article 16 was an exception to the main article of 16, and it was only a permissible way of providing reservation. But however, the 7 judges bench in N.M. Thomas overruled that view, and it held that Article 16.4 was only an emphatic saying that it is already inbuilt in Article 14 and Article 16. It held Article 14 and 16 promise an equality of opportunity to all the citizens in the country. But it said that equality of opportunity does not mean that equal opportunity to all the citizens. It said that if equal opportunity to provide it to all the citizens, then it will lead to nothing else but more inequalities. And therefore, a special treatment to those who are lagging behind was already inbuilt in Article 14 and Article 16. It has been further carried forward in Indira Swani judges bench, which held that the reservation was not an anti-meritarian, also held that the reservation could be provided even by an executive instruction, and it was not necessary that it has to be by a legislative piece. Recently, in the last year, we sat in a 7 judges combination to consider the issue with regard to sub-classification. Out of 7, the 6 of us took a view that a sub-classification was permissible. If the state government finds that even among the scheduled caste, a certain sections of the society, section of the scheduled caste are not adequately represented, and if it is found that only a particular sections in the scheduled caste have taken the benefits of the reservation, then the state cannot be precluded of its right of providing a special treatment to those who are underrepresented. I also went further and took a view that the concept of criminal layer, as has been found in the judgment of Indira Sawhney insofar as the other backward classes are concerned, should also be made applicable to scheduled caste, though my judgment has been widely criticized on that issue. But I still hold that judges are not supposed to normally justify their judgments, and I still about a week to go. But if a person who is an IAS officer, he becomes a chief secretary, and his son gets the best of education in a city like Hyderabad or Bangalore, could a child of a poor agricultural labor studying in the village, though both belonging to scheduled caste, could be equated? And my answer to that was no. It denied equality of opportunity. 3 of the learned judges concurred with my view. And therefore, the concept of equality has to be ensured that the equality should not be only a paper equality, but a real equality. Insofar as women are concerned, we know that Dr. Ambedkar used to say that women are the most backward amongst the citizens of the country. As all of us know that in Maharashtra, Mahatma Jyotiba Phule and Savitribai Phule had to fight with the fundamentalists in those times, even to provide basic education to women. And Mahatma Jyotiba Phule, to whom Dr. Ambedkar used to consider as guru, incidentally, Babasaheb Ambedkar was born in a year in which Jyotiba Phule passed away and they could not have an opportunity to meet each other. But he always considered him as a guru, and Baba Sahib said that the women are the most downtrodden in this country, and therefore he provided for equality, equal treatment to women. And we find that over the years, the equality or the women empowerment is gaining momentum in the country. The discrimination which was meted out to women was strongly criticized in the case of Nargis Mirza, wherein the women air hostesses, the rule provided that the woman air hostess on either getting married within the 4 years of employment or on the fourth pregnancy would discontinue as an air hostess. The Supreme Court said that a denial of an opportunity of a motherhood to a woman and availability of the same opportunity to a male hostess was patently discriminatory and set aside the said rule. In Vishaka, the Supreme Court laid down guidelines so as to prevent harassment to the working women at their workplace. Subsequently, the Parliament enacted a law in order to bring Vishaka guidelines and give it a statutory force. In the case of Babita Punia, the Supreme Court paved the way of equal opportunity to the women. And therefore we find that when I had been to Ladakh in the last, we have our women soldiers even in the frontiers. I have been traveling to various states over the years after I joined the Supreme Court and addressing also the judicial academies. And I was happy to note that in some of the states, 60 to 70% women are selected as a JMFC. And therefore the country has also progressed towards the women empowerment, women equality. I am happy to see a large women judicial officers and women lawyers present here. One of them is my gift to your High Court. Disha Chaudhary, who was my law clerk in the first batch, is present here. And therefore we find that in the last 75 years, we have substantially progressed when we are referring to reservation. The 103rd Amendment has provided for 15(6), Article 6 of 15, which provides for reservation to the economically weaker sections. One of the latest amendments, the 106th Amendment, provides for reservation of 1/3 seats in Parliament and the legislature to women. Dr. Ambedkar always used to say that education is very important and the rights without education are without use. Unless a person is aware about his rights, unless he is educated about his rights, the rights would not be no assistance to him. And therefore the Supreme Court, as early as 70s, in the case of Mohini Jain and Unni Krishnan, held the right to education as one of the fundamental rights. Subsequently, the Parliament, by bringing in Article 21A to the Constitution, also upheld the right to education to be a fundamental right. And therefore now we have a right to free education to the children up to 14 years. By the subsequent amendments, the empowerment of the Panchayat Raj, the Jila Parishads, the Panchayat Samitis, the municipal councils, the Nagar Panchayats has also been exemplified. The earlier view was that only the fundamental rights which are incorporated in Part 3 would only be the fundamental rights. But Maneka Gandhi onwards, the Supreme Court has exemplified that anything which flows from the trinity of Article 14, 19 and 21 would be construed to be a fundamental right. And therefore we see plethora of rights: right to food, right to shelter, right to potable water, right to medical treatment, and so on. As evolved in the cases of MC Mehta, the right to pollution-free environment, the right to potable water, and as evolved by the Supreme Court.